Okay, let me see if I get my camera going the right way. And then I'll fix my plane, my DC-3. Okay. Boy, I was flying in Martha's Vineyard. They have a grass airport, 3 runways. It's really fun to land on. And I'm up there taxiing around, like getting in the traffic pattern, and you hear over the radio that this DC-3 is coming in. And I'm like, wow, this is going to be cool. I get to watch a DC-3 land on a grass runway out in Martha's Vineyard. And boy, they don't need much runway at all. That guy was down and stopped in no time flat. It was amazing. Didn't expect that one. All right, listen, we got a couple of things I want to talk about today. This is going to be like a multifamily law school. We got some interesting stuff. I'm going to attempt to share my screen if I need to. Hopefully I won't need to, because this is through a service that is not great. But anyway, okay. First off, I want to talk about there was a release back at the end of the last year, which is from the Securities and Exchange Commission. It was a review of the accredited investor definition under the Dodd-Frank Act. Now, it appears that according to the Dodd-Frank Act, that definition of the accredited investor needs to be reviewed on a systematic basis as it pertains to natural persons, at least once every 4 years, to determine whether the requirements of the definition should be adjusted or modified for the protection of investors in the public interest and in the light of the economy. So this is, I've heard there's quite a discussion going on that the definition of accredited investors needs to be changed. And, when you think about what the problem is, you can understand why we need to have a change in the definition. It prevents, you talk about the rich getting richer and the poor getting poorer. The accredited investor question definition kicks out so many people from certain investments because they don't meet this particular standard that is set by the SEC and reviewed every 4 years. So this particular situation was they had this report, and just to give you some of the examples of some of the recommendations from these reports, what they came back with was, after the public discourse, one of the organizations recommended that the commission amend the accredited investor definition to, 1, exclude from the net worth calculation assets accumulated or held in a defined contribution plan. So those would be kicked out and not allowed to be included in the calculation. So if you think you've done well, you've saved money, you're a member of a defined contribution plan, and you can sit back and relax because you've got your retirement paid for, that the value of that defined contribution plan cannot be added to your net worth, and therefore you will not qualify as an accredited investor. And number 2, adjust the income and net worth thresholds to account for inflation since 1982, and index the thresholds to inflation on a going forward basis. So if you think, what is it, 200,000 for an individual for income and 300,000 for a family, that's going to keep growing every single year and deny many people the opportunity to become qualified as accredited investors. Now, there were a couple other recommendations that they evaluate the accredited investor definition as it relates to natural persons, stating that their expectation is that a closer analysis will reveal that a significant percentage of individuals who currently qualify as accredited investors are not, in fact, capable of protecting their own interests. Oh, clutch your pearls, Securities and Exchange Commission. The IAC also recommended the commission consider alternatives that, number one, allow individuals to qualify as accredited investors based on their financial sophistication. Okay, I'm going to come back to that one right in a moment. Number two, alternative approaches to setting the financial thresholds, such as limiting investments in private companies to a percentage of assets or income. Oh, you mean like we have to put our money into the stock market because private companies aren't good enough to be valued? Boy, that sounds like who writes these rules? Obviously, people in the stock market. Number three, encouraging the development of an alternative method of verifying accredited investor status. I'm going to talk more about that in just a second. And four, strengthening the protections for non-accredited individuals that only qualify to invest by virtue of their reliance on a purchaser representative. So let's talk about these. Allow individuals to qualify as accredited investors based on their financial sophistication, or encouraging the development of an alternative method of verifying accredited investor status. Now, okay, so the alternative method for verifying accredited investor status, that's more like, right now you can use lawyers, you can use third parties, you can use CPAs. Thinking this way of an alternative method of it being like a government entity where you've got to qualify like Medicare and Social Security. Oh, that's all we need is more government involvement. But this whole thing about allowing individuals to qualify as accredited investors based on their financial sophistication, that's a great idea. I mean, for crying out loud, you make lawyers take bar exams to see if they can practice law. Why don't you allow investors to take investing exams to see if they qualify as an accredited investor? Why should it be based upon, their investments? Oh, I had a great year, so I qualified as an accredited investor. Oh, I lost a lot of money in the stock market because I listened to those bums on TV, and now I'm no longer an accredited investor. But I'm smarter now because I'm more sophisticated and I won't invest with those bums anymore. Oh, but that's too late. You can't qualify any longer as an accredited investor because you lost money. Yeah, well, you know what they say, failure is the best teacher. So that has no credit for you as the accredited investor ruling goes. Pretty ridiculous, if you ask me. I think there should be a test. I think that people should qualify for accredited investor status and let us go off on our own. And here's why. Because we put so much weight in a certain category of citizens to protect us and defend us from enemies, both foreign and domestic. And as a result of their choice, their career choice, the chances are very good that they will never qualify under the accredited investor questionnaire. But they can put their lives on the line and they can manage millions of dollars worth of material and people and lives, but they'll never qualify as an accredited investor. And therefore, they're cut out of all of this, which I think is absolutely ridiculous. I'd love to get your thoughts on it. Tell me what you think. And of course, I'm talking about any military. The general's not going to qualify. And he's got a defined contribution plan. All right, let's move on to the next topic. Next topic. Let me see if I got any questions. Okay, good. Let's see here. All right, so this is a fun case. All right, this case is called Willis v. Eureka Multifamily Group. Now, the thing about this is this was a 2021 case, and it's about a property in Memphis, Tennessee. And it happened on March 31st, 2021. It gives the address of this property as, I'll read it to you. It's 2114 East Alcy, ALCY Road in Memphis, Tennessee. Now, what I recommend you do, and this is the fun that I have, is I like to get the story behind the story. So go and type in the 2119 East Elsie Road, Memphis, Tennessee, and you'll see that not only is this property still standing, there it is, but it's also managed and owned by the same company, Eureka Multifamily Group. Their name pops up right there. It's a one baths, two bedroom, one bedroom, two bedroom, three bedroom, and four bedrooms. None of them are available. None of them are available. 100% occupancy. How do you like that? Good job, Eureka. All right. So what happened here in this particular case, and this is something for those of you landlords or budding landlords, this is something that you really need to understand. One thing that came up in this is something called the Uniform Residential Landlord and Tenant Act. Now, whenever you hear the word uniform before an act, that tends to be the American Bar Association. They try to put together committees to create draft legislation that is uniform throughout the country. And what happens is they draft it, and then it gets picked up state by state by state by state. This Uniform Residential Landlord and Tenant Act, I think, was kind of drafted back in 1972. It has not been picked up by all the states. And every state that picked it up modified it in some way, thereby not making it very uniform. But this is I started looking at that particular law, and it's very interesting to see how they, they're trying to create Landlord Tenant Act uniformity across the board. So this is a premises liability case. So the plaintiff is the tenant, and they entered into a lease with the Eureka Property Management Company to rent an apartment at this Hillview Village Apartments in Memphis, Tennessee. This was around 2019. And the plaintiff reported to the property manager that the transition strip in the doorway separating the kitchen from the living room was protruding up. It was popping up. And this doorway was the only means of entry and exit between the apartment's kitchen and the other room. So what do? She put in a work order on that same day. And before property management could get a opportunity to get in there and fix it, she tripped over the transition strip 7 days later. Now, the lease agreement provided that the property management company would make necessary repairs with reasonable promptness. It's in the lease. And their employee completed the work order concerning that strip on the 11th. So 2 days later, completed the work order concerning the transition strip. The plaintiff has not reported any further problems since that time. Now, the plaintiff admits that she was able to walk across the strip, albeit with some difficulty, in that intervening 10-day period by the time she moved in and by the time that she had it fixed. But she also admitted that her son, who also lived in the apartment, had no issues going over that strip. Okay, now the court case goes into a whole lot of procedural issues regarding summary judgment. The court will grant summary judgment if one of the parties shows that there's no genuine dispute as to any material fact, and the party is entitled to judgment strictly as a matter of law. So there's a whole lot of it. It has to be filed in a timely manner. In this particular case, it wasn't. And so what ended up happening was this. So this was a federal court case, all right, which obviously means she was suing for a lot of money. And, she wanted to get that bigger payday. So she decided to take it to federal court. And what happened was let me just find, let me see, I lost my, okay. So the plaintiff alleged the defendants were negligent in their maintenance and supervision of the property. Now, a prima facie claim of negligence consists of four things. First, you have to show that there was a duty of care owed by the property manager to the tenant. Now, I'm putting their titles in here differently. I'm not using the typical legal terms, which is duty of care owed by the defendant to the plaintiff. All right, I want you to understand who's suing, who's responsible for what, and that conduct fell below the applicable standard of care, amounting to a breach of that duty. So did they owe the care, and did their behavior fall in such a negative way that it caused that problem? It caused an injury or loss. That's a third thing. And that the injury or loss, that what their failure to care was the causation of that injury or loss, and therefore the proximate or legal cause of the damages. All right. So it's the tenant's responsibility to prove all of the elements of that negligence, or they lose. And so what the defendant filed a motion for summary judgment saying, hey, they can't prove all of those things, so therefore we don't even need to go to trial. You should just grant us summary judgment and let us get out of here. Now, I'll tell you right now, any lawyer listening to this case right now knows as well as I do that federal case, the plaintiff's attorney's looking for a payday, and was hoping that he could just get out of this one quick and easy, hopefully settle it. Didn't think they'd have to go into legal proceedings in the federal court, but not so fast. They're using Tennessee law. Even though they're in federal court, they're using Tennessee law. And the general rule in Tennessee is that a landlord is not liable to a tenant or any other third party for harm caused by a dangerous condition on the leased premises. Wow. Obviously written by the landlord bar. This rule has been faithfully applied in many scenarios. All right. And this general rule applies to both residential and commercial leases in the state of Tennessee. Now, this rule, however, has several notable exceptions. The parties' arguments implicate two of these exceptions. All right. So the first exception comes into play when the dangerous condition was in existence at the time the lease was executed. That's an exception. All right. And number two, the landlord knew or should have known of the dangerous condition. And number three, the tenant did not know of the condition and could not have learned about it through an exercise of reasonable care. So what they're calling that last condition is coextensive knowledge. In other words, that the exception is the landlord will not be held liable when the tenant has coextensive knowledge of the dangerous condition. Okay, now think of the facts and the way I gave them to you. She signs the lease on February 1st. She reports the condition on February 2nd. She trips and falls February 3rd, and it gets fixed on February 10th. I'm not giving you the exact dates, but you can see the chronology of events. The second exception arises when the landlord has a contractual duty to repair and maintain the leased premise. Hold on, I think I jumped ahead. Let me see. Defendants argue that the general rule of landlord non-liability applies in this case because it is undisputed that the tenant had coextensive knowledge of the dangerous condition. The plaintiff counters by invoking the exception to the general rule involving negligent repairs. Now here, the tenant has failed to negate the application of the general rule, so we don't care about the exceptions. It is clear that the court that the plaintiff, the tenant, had coextensive knowledge of the dangerous condition that caused her injury, and therefore the plaintiff, the tenant, informed the landlord of the issue with the transition stip. Further, she and her husband had to walk over it for the next 10 days or so. Barring some other exception, the court will apply the general rule of landlord non-liability. So, folks, the tenant loses because of that coexistive what was it? I'm jumping ahead once again. Coextensive knowledge provision. So that is definitely something that that plaintiffs. Let me see. It comes right down to the end here. Conclusion: for the reasons above, the court grants defendant's motion for summary judgment. Judgment will be entered in the landlord's favor and dismissed with prejudice. So I'm telling you, folks, there was one plaintiff's attorney who was hoping for a payday and didn't get it. So too bad, so sad. Landlord, good guys win, as we say in the business. Good guys win. All right, there's one more case I want to talk to you about. And this is something, well, actually, this one has to do with COVID. And I want you to understand things that you should have added or write protections against in your lease. This is why you need to make sure that your lease is up to date. This is a COVID-19 pandemic issue, okay? And this one it went to the state Supreme Court in Connecticut, but this is why you must always check with local counsel. Make sure you go in there and you make sure that you're doing, that you are complying or making sure that you're protected against the next pandemic. Okay. So what happened in this particular, and now remember, this was a commercial tenant, and the court sees commercial tenants and residential tenants entirely differently. But I want to tell you about this commercial case and make sure, because some of you might have some, some of your first floor properties. The first floor might be commercial tenants. So just remember this. All right. So in this case, a restaurant and bar operator, that was a tenant, stopped paying the rent due to the closure of its business by the governor's executive orders during the pandemic. And now the landlord terminated the lease and filed a lawsuit to collect unpaid rent and damages. Now, obviously, there must have been a personal guarantee written in this particular lease. The tenant asserted defenses, including impossibility and frustration of purpose. And the trial court ruled in favor of the landlord, finding that the tenant was not excused from rental obligations based on these defenses, but did not award full damages due to insufficient information on the mitigation efforts. Okay, folks, the defenses by the tenants in this case were two common law defenses, contract defenses of impossibility and frustration of purpose. Make sure that you've got protections in your leases to protect you against that type of defense being used against you for any type of breach of a tenant contract. All right. I'm not talking about duty to mitigate. That's going to be another topic coming up on one of our future multifamily law schools. But I'm just speaking right now to these particular defenses that are common law defenses in contracts. Now, the Connecticut Supreme Court affirmed the lower court's decision, stating that the executive orders and pandemic did not make lease performance impossible. In other words, the guy could still use the space for maybe not for its intended purpose, but he could still perform in that space. The court emphasized that the tenant could have provided curbside or takeout service, which was not prohibited by the lease. Now, regarding frustration of purpose, the court concluded that the lease's purpose was not frustrated by the pandemic, highlighting the absence of limitations on certain types of dining and takeout. So, hey, don't blame us. You can still use the space, and that's what you signed up for. Now, additionally, the Supreme Court addressed the burden of proof on the mitigation of damages. It clarified that when a tenant breaches a lease, the tenant is the one that bears the burden of proving that the landlord failed to undertake commercially reasonable efforts to mitigate damages. There's that expression. The landlord's responsible for mitigating damages. Not in all cases. Residential, commercial, different duty to mitigate. And so therefore the court reversed and remanded the case to the trial court for further proceedings on the damages. So that is today's lesson. Always fun, always good stuff in the court world, especially as it relates to landlord, tenant, and multifamily law. If anybody has any questions about anything, chime on in. If anybody has any topics you want me to cover next time, I'd love to hear them. I have upcoming. We have the multifamily hotels to homes cohort meeting on Thursday for those members of the cohort. Those of you interested in finding out more about our upcoming offering for hotels to homes, you should just reach out to me. I'll make sure I get you all the information. And that offering is a 506c, which means that it's for accredited investors, but there's a crowdfunding way that you can enter into that offering as well. That's being taken care of right now. Very excited to have all those types of people involved, because this type of hotel to home conversions benefits the little guy. And what better person to invest in it than people that don't qualify by the SEC's guidelines for accredited investor. So we take accredited investors for the 506c offering, but through another channel of crowdfunding, you can get into this deal as well. All right, everybody, great to see you all. I will see you again on Thursday. On Thursday, same time, 3 p.m., we'll be talking about a particular property. It'll be a lot of fun, and I'll see you all then.